Helping Seniors Television, all about improving quality of life for seniors. If you're a senior, know a senior, or plan to be a senior, then this show is for you. It's all about helping you develop your own aging plan so you can age actively and with dignity. Helping Seniors Television from the Helping Seniors Network of information, education, and resources.
Welcome to this edition of Helping Seniors Television. We're the Florida, the nonprofit that is invested in putting together information, contacts, resources that will help you develop your own aging plan. As Joe Steckler, who is our founder and he's now chairman emeritus, has often said, we all need an aging plan that helps us really prepare for the things that we might run into on the road ahead. Living in Florida, we get hurricane plan. Aging plan is sort of the same idea. It doesn't mean you want a storm to hit you. It just means you want to be prepared. And with that in mind, so honored to welcome a good friend of the Helping Seniors organization. He is attorney Greg Schwendeman with Rhodes Law, PA. Welcome, Greg. How are you?
Good. Thanks for having me on today.
I'm so glad you're here because we're going to have a conversation about guardianship, which is something you're really quite an expert in. And I know for a lot of cases, we talk about the fact that probably as a general rule, better to avoid guardianship unless there's no alternative. And how we could do that is often through by getting our paperwork done ahead of time so we're not finding ourselves in that situation. But I like how you explained the tactic that we're going to take on the show today to really have us get into the nuts and bolts of guardianship, because sometimes it is just what is required. And I love how you, just before the cameras were rolling, you were telling the story about how people will come into the office and mom or dad has dementia and they really want to get a power of attorney because they realize mom or dad can't handle things. But now apparently we're past that because guardianship really becomes the alternative. Can I talk about how it is when you sit down with a family that comes in and you have to explain them kind of the facts of guardianship?
Yeah, sure. That's a sad call because many times they'll call us and they'll say, well, mom or dad has dementia and they cannot do anything. They have a doctor's note saying dementia. And many times it's too late. It's too late. And so we sit down with them. We explain, well, what do you need? And we have to try and avoid guardianship. It's not that we steer them into guardianship because the courts must inquire. When we file guardianship papers, the court is bound to ask if there's a least restrictive means to guardianship. Because short of putting a person in prison, guardianship is the most onerous thing you can do to a person.
Wow.
Yeah, so we try to look for any way. Sometimes a person does get a diagnosis of dementia, but they're not bad yet. But they have the diagnosis. If we can have the doctor put a letter on his letterhead stating that, yes, they have the unfortunate diagnosis, but today they can still execute the legal documents, then we would go ahead and execute the durable power of attorney, a healthcare surrogate, and a living will, and a pre-need designation of guardian. And those are generally what you call the advanced directives or the least restrictive means. Yeah. That's what the court would look for, because then we can avoid a guardianship in most cases.
Well, that certainly sounds helpful and hopeful. And it goes back to, Greg, we've always had this, Joe calls it an aging plan. We call it getting your ducks in a row. And what we mean by that is you're just so much better off if you can take a couple of steps now while there's no pressure, no emergency. Mm-hmm. And typically it's less expensive. It's typically you have more options and you have way more control than when you get into guardianship. But, I guess things happen in life. Maybe somebody has a stroke and they're non-responsive and now the mortgage company is yelling that the house payment needs to be made. So there's times where you can't even have the opportunity to explore those. You just have to figure out what's next on the list. And is that maybe another example of where guardianship falls into place when the documents don't exist?
Absolutely. Guardianship's there to help someone take decisions for you, make decisions for you, and carry out basically the three areas of our life we all have, which is our legal, our financial, and our medical. But what you said a moment ago is probably the saddest thing when you think about it, is I have had multiple times where people come to me for a guardianship because unfortunately their mom or dad, who now has dementia, didn't want to spend a little bit of money years ago, or even a few years ago, and sometimes even months ago, to have these documents prepared. And that money is far less than a guardianship, especially if it becomes a contested guardianship.
Yeah, I know from talking with Ruth Rhodes, Rhodes Law PA, and she's explained to me that really the guardianship becomes very expensive simply because you now have attorneys involved in places that maybe they otherwise wouldn't need to be involved. But the reason they have to be involved is because it's all a court-guided system. And so all of this is required with the guardianship. And I know I've heard her say, what amounts to very inexpensive opportunity to put paperwork together ends up costing significantly just because of what it's required in the guardianship world. But I wanted us to take this from the tactic that maybe guardianship is necessary. We don't have another alternative. What does that actually mean? Once you get somebody into the thinking like, well, we're here, this is what we must do, how do you start to work with a family and say, okay, this is what a guardianship means, this is how we prepare for it, and this is how it's going to work?
Well, when they come in and meet with us, we go through, first of all, let me say it's more of a collaborative process. Okay, so our client is normally the person who's going to be the petitioner. So we will file petitions asking the court to begin the guardianship process. And we're talking about this with one word, guardianship. But it's important to realize we're really talking about two cases, a mental health case and a guardianship case. And so when we work with the clients, they're in our office, we give them paperwork to fill out because we need to know everything about them, everything about the person they're applying for guardianship for, known as the alleged incapacitated person. Once, of course, they're adjudicated as incapacitated, the title changes to ward, but many people use it interchangeably. So we get all of this information, we compile it, we put it into pleadings, and we file with the court. And when we file with the court, one of the things, the judge has no discretion. This goes back to cost. The judge must appoint an attorney and Elisor to represent the person with dementia or the incapacity, right? So that's one person. Then the judge must appoint a 3-person examining committee to go out and examine. And the good thing about that, a lot of people say, "May, why all these other people involved? I don't like that idea." Well, I think it's a great idea. The reason is there used to be so much abuse and fraud in the Florida system that the legislature put these requirements through where the judge doesn't have that discretion to make sure that the guardianship is in that person's best interest and that they truly need the guardianship. So that's very good. But we explain all of this to the person, to the clients when we're sitting with them, what that process is and how it goes about. Because if 2 of the 3 examining committee members come back and say, "No, grandma's fine," that's it. Statute says that the court shall dismiss right there. Case is over. 2 out of the 3. So we go through all of that. And we also find out, does the applicant who wants to be a guardian, are they, for example, convicted of a felony? If so, they are not qualified. But we also try to find out if there are those documents you had mentioned, the durable power of attorney and healthcare surrogate. Because sometimes they're there and people don't realize it. They mix up terms all the time. They'll call a last will a living will and so forth because they're not attorneys, but we work with them.
Yeah. So when this process comes down, that we have to go through this process of determining, I guess that's the first stage, that there has to be an adjudication that, yes, we agree this person is needing to be under guardianship. And once that happens, then what happens?
Well, let me back up for a second because what we would do is, and you have to work with the clients, right, and see what the story is. And sometimes everybody's on board and grandma's safe. There's no emergency. And you just proceed accordingly. Well, what also happens is in Florida, we have something known as the emergency temporary guardianship. And then under that statute, that is where And it gives, of course, a whole long, lengthy description of what it is. But it boils down to the courts look out for the health and wealth. There has to be an imminent harm to the health or wealth of the person. And so if that happens, and that comes out where grandma is putting herself in harm's way, even if she has a power of attorney, that doesn't mean she has to listen to whomever she named in the power of attorney, by the way. A lot of people think it gives them a solid footing. It doesn't. She doesn't have to listen to you. And if she's putting herself in harm's way, not taking medication, becoming a silver alert, getting lost, and you're worried, oh my gosh, she's going to get hurt or injured or so forth, then that's the health prong. And of course, the wealth prong is something that unfortunately we're seeing more and more. And my own father was almost a victim. Thank God he's not incapacitated in any way at the age of 91, but he did receive a call where they tried to scam $10,000 out of him, something that's very common, the grandparent scam, where they call and say, hey, your grandson, we just arrested him on this charge. You need to give money, right? So that's where you have the emergency where the person who's incapacitated, grandma or grandfather in this case, would be given $10,000 to strangers who just say, your grandson's been arrested, or unfortunately giving tens of thousands of dollars to charities. And, so the money's being depleted, and that's the wealth prong. So of the emergency temporary guardianship. And if we get that, we go to court, get that can last up to 90 days and it can be extended. But in the reality, an emergency temporary guardianship lasts much less than 90 days.
Now, I've heard too, as we talk through this, because I'm thinking like that would seem logical, like if the person is being scammed and not able to determine that they're being scammed, it seems like some sort of protective help is needed. But at a point when the court now appoints somebody to be the guardian, which is, I guess, the point. You have the guardian who's the person looking after the person we're concerned about, and the person themselves is called the ward. Am I saying that right?
Yep.
Okay, so now who can be a guardian? Do you always have a professional guardian? Can a family member be a guardian? How does that work out once you get to the point, say, okay, we're going to need to go and we're going to have to talk to the judge about organizing a guardianship? Seems to be what's required here. How does that work the next step? Who decides who the guardian is?
Well, that's something that we do as attorneys when we meet with a potential client, basically at our initial consultation. And we put it into the petition. So the short answer to your question is yes, all of the above.
Okay.
In the statute, it gives a listing of preferences and so forth. But anyone in the state of Florida, and this is also a bit scary if you think about this, anyone in the state of Florida can petition to be the guardian of someone else.
Wow.
Okay. So normally what we have is a situation where the adult son or daughter is applying to be or petitioning to be the guardian of mom or dad. That's the normal situation.
Okay.
And it was because of so much leeway in Florida law, old leeway, that the legislature is tightening down and trying to make it more restrictive. But we do tell them, yes, you can be the guardian once we review and see that there is no bankruptcies filed or no felony convictions and so forth. So that's where we start. We find out who are they, what's their relationship. Now, some people, Florida is a very transient state. You have people who retire, let's say New York or Pennsylvania, when they're 65. They move down here to Florida. So for the next 20 years, they're enjoying Florida life. Now they're 85 and something happens and they need a guardian, but their family's still up in New York.
Yeah.
So many times what will happen is the family member will petition to be the guardian and may nominate a professional guardian to take over and actually be the guardian, sort of hand the football off, right? Or they may remain the guardian and hire a professional guardian to act as a case manager who will essentially perform the same jobs. But it helps them have boots on the ground when you're out of state.
Well, and that's another question. Like you mentioned, contested guardianship. Is this like where the family is fighting amongst themselves or trying to figure out what's best for mom? Or what do we mean when we say contested guardianship?
Contested guardianship is put it this way, it's one of the areas of law that make me thrilled. I'm an only child.
Oh, wow.
Contested guardianship is what the name says. And usually we find that where, unfortunately, and most commonly, you're going to have sibling versus sibling.
Mm-hmm.
And guardianship is also one of the only areas of law. In fact, I think it is the only area of Florida law where you must be represented by an attorney. Did you know that? You can go out, kill a person, and represent yourself in a murder trial.
Wow.
But if you want to be in guardianship, you have to have an attorney. So the bad part is, and this is why I keep preaching, and I think you've heard me preach about having a hurricane plan, right? Get your documents in a row, your advance directives.
Right.
Because there was a case, for example, where I had 8 siblings. Mm-hmm. They all hated each other.
Oh, no.
So all 8 siblings had their own attorneys.
Wow.
Can you imagine the legal fees in that case? Because every time one of them files a motion, the others, we all have to respond to the motion, have a hearing, all 8 attorneys. Yeah. And guess who pays for all 8 attorneys? Dad. Dad had a manufacturing company with a couple million, right? I'm sure that was a motivating factor. But under the law, it says that the guardian, if he has the assets, must pay for his guardianship out of the assets of the guardianship estate. So that means Dad pays for all
the family squabble.
Yes.
Oh, my goodness. So in a right case, though, where somebody is trying to be correctly and there's not all the other part of it, but there's a lot of work to being a guardian too, right? Because everything gets reviewed by the courts at certain points, and there's a lot of responsibility that goes with being a guardian as well.
Yes, but it's not as bad as it sounds.
Okay.
I'll throw that out there.
Okay.
First, the way I explain it to many clients is if you think of a heartbeat, right? You have the boom, boom, the big one, and then a little one, then it lays flat for a while, and then another. So all of the work, all of the heavy lifting is that first big bump from the time of our initial consultation to filing the paperwork and having a hearing and you get appointed guardian.
Right.
That's where all the real heavy lifting is. And then after that point, you have to file an initial plan and inventory. And then it lays fallow for about a year, what I call the anniversary date when you're appointed and the court decides that different reports are due.
Right.
So then every year thereafter, you have to file an annual accounting and an annual plan.
Okay.
And for many people, it's not that difficult of a process.
Yeah.
We can help with that. And it's usually takes just a few hours a year. The only thing I tell people is make sure you keep track of every penny.
Yeah.
Every penny. But it's not that hard, and we can assist with that.
So when is it make sense for somebody to have a professional guardian? I mean, as the actual primary guardian, I understand like maybe kids live in, like you said, they live in New York State or something, and they're just not down here. So they have somebody who's basically operating under their auspices. But when would you say, like, I'm really not the right person to do this. We need a professional guardian to help mom or dad. How does that then work?
Usually, like you said, the number one situation like that is where they're out of state and they just say, hey, I can't do it.
Yeah.
I'm up here and I'm too busy.
Yeah.
So that's the first case. Second case is in a contested guardianship. Let's say we have brother and sister.
Okay.
They both agree mom is incapacitated with dementia. That's not an issue. But both of them want to be the guardian. But then we're able to, we being the attorneys involved, are able to say, listen, you guys both have mom's best interest at heart here. Why don't we just get someone who's neutral, a licensed professional guardian, and we'll provide the documents, make sure you're involved, you can see things, but mainly take it out. You guys can go back to the favorite role of being mom's child and let the professional guardian do the heavy lifting. And in most cases, certainly not all, but most cases, that kind of rationale plays through.
So if you are sitting down and you're talking to a family and it looks like guardianship is the lane that has to be employed to resolve a case that's happening here, This seems like there's a lot of different dynamics that come into play. It looks like what's going on with the person, looks like what's going on with the family and those dynamics.
Mhm.
And then you have to make the best call that you can to put everybody really in the best seat as you can determine is going to be successful. Is guardianship typically for a senior, does that become for the rest of their life kind of thing? Is there times when somebody may just be going through a severe medical episode and then it's okay
Yes.
after a while or something?
Yes. In your typical guardianship,
Mhm.
the answer is most likely guardianship will be in place until they die.
Okay.
Because when I say typical, I'm talking about dementia.
Right.
And dementia is unfortunately, at this point in time, a progressive
Right.
and incurable disease. So
Right.
it's going to keep getting worse until they pass. But then you do have those cases where someone may have um, perhaps a traumatic brain injury that they
Mhm.
can recover
Mhm.
from. Or we have one case right now where I'm working with the attorney on the other side because we realize the alleged incapacitated person is is recovering very well under the proper medical care,
Yeah.
and we might not need a guardianship, which would
Wow.
be great.
Yeah.
And that's one of the bad things is there are a lot of underlying medical issues that people are unaware of that are masking or giving you
Yeah.
let's call it a false positive
Right.
for dementia. One of them could be a urinary tract
Right.
infection.
Right.
Once that's gone, there's no need, and
Yeah.
and you can petition the court to discharge the guardianship.
Wow.
So it's not that you're handcuffed into this forever. Sad reality is many people will be in the guardianship till death. That's it gives us an option.
Yeah.
If we can get out, we will get out.
Yeah. So as we began the conversation, we said typically it is better to avoid guardianship for all the reasons we stated. It's just expensive. It's time consuming because the court has to be involved in certain steps.
Mhm.
Are there times when guardianship is actually like a preferred outcome? Like this is what we need to do just because of the fact of whatever the situation is.
Yeah, absolutely. Um, and many times that involves situations where you will see, unfortunately, the ward outlive everyone in the
Uh-huh.
family,
Uh-huh.
and maybe there's no one else to take care of them,
Ah,
right? And they're getting up there in age, whether it's dementia or something else, they need a guardian.
yeah.
And so what happens is we can usually get a professional guardian appointed who will help that person. And I work with a bunch of different
Hmm.
professional guardians in town. I'm proud to say, you know, who they are, but they're great people that really they don't take it as a job. They really
Hmm.
care for the people they're looking out for.
Yeah.
And those are the ones that I like to suggest be appointed. But they help out in those situations where there's no one else, no friends, no family. And at some point you find yourself alone.
Yeah.
So who's going to help you? You need a guardianship.
That's an interesting point. So, if somebody has questions about everything that we've been talking about, I know that typically the first place to start would be that if we can avoid guardianship, typically
Mhm.
we're looking for as you said, a least restrictive means. If there's another option, maybe we're going to go for that.
Right.
But as people are sorting through what all of this means, we always say, don't try this on your own. You need to talk to somebody that has been down this road and
Yes.
can help you navigate and figure out what's best because everybody's fact situation is going to be a little bit different. I think this is where experience matters. So one of the corollaries that when we say get your ducks in a row or build your aging plan, we always say, don't try this on your own. Get a hold of somebody that really knows the lay of the land, whatever area of aging that we're talking about. It could be we're
Mhm.
talking about people trying to work through insurance problems, get an expert who is
Right.
local and can advise you. And I see so many people do so much great damage to themselves. They get out on the internet
Absolutely.
and start searching. And particularly in legal, that seems like a terrible place to be because you don't know if you're getting up to the minute what the laws are today. And you don't know if you're getting it for the right state that you're concerned with. And all these are dynamics you have to think through, right?
Absolutely. Some of the worst things I have seen come across my desk have been instances where a person tried to do it themselves. They got a form online.
Yep.
Or they've gone to a non-lawyer service.
Uh-huh.
These are places where they get forms and they're not allowed to get legal advice, and sometimes they do.
Mm-hmm.
And it creates not only an enormous problem, but a very, very expensive problem.
Yeah.
I would say that you need, if you're going to do any of these things, whether it is drafting the documents beforehand, especially, right? You need an elder law attorney.
Yeah.
You don't just need an attorney, because I had one person come to me whose documents were drawn up by a friend who was a lawyer. But this lawyer practiced a different area of practice.
Yeah.
They did not do elder law, and their documents were horrible. It's just like, you may be a doctor, but if your specialty is brain surgery, you're not going to do a different area, right? You're going to focus on what you do, and your patients should go to you for that area. Same thing with us. Go to an elder law attorney who will draft them for you.
Yeah. So we're talking with Greg Schwendeman of Rhodes Law, PA, right here in Melbourne, Florida. Greg, if people want to get in touch, they have questions, they want to learn more, maybe everything we're talking about convinces them that they do need to get their ducks in a row and get some paperwork going, what's a good way to get in touch with the law office?
The best way is to call us at 321-610-4542.
All right. Let me have you say that one more time.
How about twice?
Okay.
321-610-4542. That number is 321-610-4542. And if you're calling for a guardianship question, I do give a free consultation, the initial consultation for guardianship. So I would suggest please write down any questions you have and bring them in, and I'll answer them.
Sounds great. Well, thank you, Greg, for sharing your time and expertise. And thank you, viewer, for joining us on this episode of Helping Seniors TV. We'll see you soon.
I'm Joe Steckler. Thank you for joining our program today. I'd like to remind you that our senior information line is available to you at 321-473-7770. There you can get help and direction that could be helpful for your specific situation or circumstances. The work of helping seniors is very important, but we can't do it alone. That is why our sponsors here in Brevard County are so important. I'd like to thank our many area sponsors, businesses, and medical providers who support the mission of helping seniors that help us carry the cost of our media efforts. If you'd like to join us either as a business partner or simply donate as an individual, we welcome your call at 321-473-7770. You are always welcome to visit our website at www.helpingseniors.brevard.org. Thanks so much for your help. It does make a difference.